Good morning, good afternoon, or good evening, depending on wherever in the world you may be. It is my utmost pleasure to invite you to this session by Professor Bryan Mercurio of Chinese University of Hong Kong. Before I formally invite our speaker to deliver his talk, just allow me a couple of minutes to say a few words about our today's topic. I think this topic is not just a topic for law students or for those of us who have interest in international trade law or international investment law or broadly international economic law. I think this is a topic which is very important for the current time, and who knows, maybe even the next pandemic which we might face. Professor Mercurio has written some wonderful pieces in this area. His works have been published in leading journals such as International and Comparative Law Quarterly, Virginia Journal of International Law Online. Professor Mercurio's points are very well made. Not every one of us may agree with what he says, but when a serious scholar like Professor Mercurio makes his point, it is not easy to refute his points. His points are legally very coherent. His points are very much policy oriented, and his points, even if you disagree with him, you would find your task really tough, a tough one. Let me just briefly say a few words about the recent waiver that the WTO has agreed in the last ministerial conference. Essentially, those who oppose it, they are arguing, as Professor Mercurio perhaps might in a way imply, as I gather from the title of his talk, that is it really necessary, or was it really necessary to get a waiver, or was it just a flexibility that could perhaps be something that we did not need? Or another question is, by this waiver, would the vaccine or other treatments to COVID, would that be easier to access? So that is an important question. Legally speaking, particularly one question that I can think of as a student of international law, that yes, this is a waiver that WTO members may avail, but that would also be something that has to be implemented at the national level. And at the national level, there are many investment agreements that may come into conflict with the flexibilities that the states may adopt in their domestic law. And in international law, except for use clauses, there is no clear-cut hierarchy that your WTO waiver can be used as a justification for your investment obligations. So that for sure is something that would be at issue in future cases. And beyond that, if I talk about those who argue that no, this waiver is not going far enough, some would argue that this is only talking about COVID vaccine, this is not about other treatments of COVID. Some would say, why only for 5 years? So this is an area which is practically important and also divides our opinion. So I'm very much eager to see what Professor Mercurio argues today. And of course, I look forward to see how the audience puts their comments and questions. I once again thank Professor Mercurio for his time. Professor Mercurio, over to you.
Great, thank you very much. It's a pleasure to be with you today, and I think as well that I have to say that the class is very lucky to have Professor Rizwan as a professor. You're very not only knowledgeable but also proactive, and it's a great initiative, I think, to bring speakers and to get other perspectives. So it really, I think the students are quite lucky to have you. I'm just going to share my screen now. I will stop the view. Okay, so I think that you know what as Professor Rizwan has mentioned, I have, shared my views on the desirability or otherwise of a waiver in a few papers, and also the potential conflict with international investment law. I'm happy to take questions on that aspect, or on any aspect of the waiver as well. I think, by the way, in the investment context, I think it'd be a very limited chance that a country that was implementing a waiver, if in fact we had one, would be liable under investment law. But today's talk is really just to go over the process of what happened, and to to kind of go over this ministerial decision which took place, and some of the the happenings, and what I would like to also then kind of conclude with is, well, what effect is this decision going to have? And the conclusion really is, well, I don't know. I mean, none of us really know, right? What effect? On the one hand, you have some saying it will have no effect whatsoever. On the others, you say this is, who say this is fantastic. I'm probably falling somewhere in the middle, but I will get there. So the background to this, I think we have to just to go back. What we'll say is, I think the debate about the role of intellectual property rights, in particular at the WTO and TRIPS, and public health has never really gone away, right? You'll have health activists and some countries who, really will try to take every opportunity to roll back protections, or to, point out some of the failings of the system, etc. I mean, this all kind of boils down to the question of whether TRIPS facilitates or blocks access to vaccines and treatments. So without, with no surprise, the pandemic really reawakened this debate and put it in the forefront. Now, there was action taken from the start, really, at the multilateral and domestic level. Now, what do I mean there? Well, at the multilateral level, you had quite a number of international organizations looking at issues such as, trade blockages, country level export bans, supply chain issues. So the WHO, the WTO, and other, even the IMF, really were looking at these issues. The IMF, obviously, from a funding point of view. And you also had at the domestic level, well, some countries, of course, having the export bans, or really trying to ensure that what they thought they needed did not leave the country to go to somewhere else. But then also you had, even in March 2020, countries as diverse as some in South America, like Chile and Ecuador, to even Canada, Germany, Israel, Indonesia, Hungary, legislating for emergency action, including the possibility of compulsory licenses, of the issuing of compulsory licenses for vaccines and treatments. At that point, really, we're talking about treatments because there were no vaccines. And compulsory license, just to go back in case if you don't know, is exactly what it sounds like. It is when the government will essentially hand the recipe over to someone else and say, whilst the owner of this patent, the rights holder, has the exclusive rights to use, to make, to manufacture, to sell, we are, for a temporary period, allowing someone else to do that because there's a shortage, because prices are too high, because our local needs are not being met, etc. This is allowed by Article 31 of the TRIPS agreement. So the call for a waiver, though, began also in 2020, and you had India and South Africa propose quite a broad waiver from certain provisions of the TRIPS agreement. Now, actually, it was the entire sections on copyright, industrial designs, patents, and trade secrets. So quite a far-reaching waiver, so that no one, again, at the international level, if someone, completely, well, I'll just say the difference there is under a compulsory license, certain procedural steps need to be taken, as well as adequate remuneration needs to be paid for the right to the rights holder. Under a waiver here, you're essentially acting as if the TRIPS agreement is not enforced or does not apply. And at that point, no procedural steps need to be taken, no remuneration needs to be taken. It's as if, again, for that time period, there are no intellectual property rights there. So most developing countries immediately supported this proposal. The opposition, as you can imagine, came from the US, the EU, actually originally Canada, Australia, Norway, Switzerland, but also developing countries like Mexico, Chile, China. They were a bit lukewarm. Actually, if you look back at the TRIPS Council meetings, they were asking, well, how are we going to operationalize this? What does this mean? Of course, China likes to position itself as a developing country, but remember, they were at that time in the process of developing several different vaccines from different companies in China. So they really kept their mouth shut there. Now, this proposal was quite broad, as I mentioned, and also really didn't really have an end time frame. I'm sure if you've been studying WTO law, you know that consensus decision-making rules, and it means that every country has to agree to change something. And what the original waiver had said was essentially that the waiver would remain in force until the General Council decides otherwise. Now, that means every member, right? So only one member, if they say no, that means the waiver would stay in force. So what I argue is basically it's an indefinite waiver with no real end date as the proposal. Now, this proposal really did not go very far until May of 2021, when the US essentially reversed its positions and said that it supported negotiations for a waiver on vaccines. Now, this was not in line really with what the original proposal was. The original proposal actually was not just for vaccines, but also for diagnostics and treatments, okay? So what the US said they proposed negotiations on was narrower than, in fact, what had been proposed. About 2 to 3 weeks, China, by the way, immediately reversed their position and said they too then supported waiver negotiations. So did eventually Australia and Canada, but you still had Switzerland, the UK, Norway, and the European Union really opposing even the negotiations at that stage. We can talk further about why the US did this if you want. I think it's a lot of politics behind it. And also, I think it just put the pressure on the EU and away from the US. So about 2 or 3 weeks after this US reversal, a revised proposal came out. I was a little disappointed in that proposal, I have to say. There was momentum for a waiver, but the revised proposal really did not change much from the original proposal. And in some ways, I think was almost a slap in the face to the US, who had, of course, said they supported negotiations. And then you come up with a revision, which is basically the same thing. It applied for, scope was the same, coverage was the same. While they changed the wording of duration, it was still going to last an indefinite period of time, which is something that the US just would never have agreed to. Now, I won't, in some of my papers that have been out, I have argued against the waiver. I didn't think it was necessary, and I didn't think it would do what proponents wanted it to do. And I thought it had some real negative consequences. This talk is not to convince you of that position or to argue against the merits, but I think I need to go over some of the merits and some of the detriments. So really, what are the arguments for and against the waiver? I think, there are many arguments in each side, but I've tried to distill it down. So if you look the TRIPS, I think what we have in that original and revised proposal is the same. The TRIPS provides limited options to overcome IP barriers. So the starting point of the arguments for a waiver is that IP could be a barrier to access in order to prevent, contain, or treat the pandemic. And the second corollary to that is that there are limited options to overcome that. What does that mean? It means there are limited flexibilities built in the agreement. Now, there are actually many flexibilities. So the related argument there is, well, there are flexibilities, but they will not work. They weren't meant for pandemic situation, and they're difficult to implement. That was another argument against. Likewise, a further argument, for the waiver. Likewise, another argument for the waiver is that IP would restrict the scaling up of manufacturing because, of course, you have the IP locked in with certain companies, and that they would only license on a limited extent, which means that we have less suppliers, less competition, and therefore, of course, less likely to scale up manufacturing to meet our needs. And I put it rather bluntly in the slide, but it's true. The other argument against was that the international efforts will fail, is that the international efforts led by, say, WHO and joint initiatives, we have a few, one called CTAP, one called COVAX, like a license sharing a sharing agreement where companies agree to license out their IP. Essentially, the proponents said that's not going to work. And so we can't rely on that. The arguments against the waiver were that, of course, that it was unnecessary, that in fact, and maybe because of IP, or at least partly, that the medical community and the research community was responding, and that there didn't need to be a waiver because, in fact, there would be enough treatments and vaccines. Second was that a waiver would, if it led to more manufacturers, it would also lead to less quality manufacturers. So there could be some problems there. And that also it would be potentially harmful to supply chains. Now, what this means is, we're not just talking about active ingredients. So for a while in 2021, we had essentially a little reduction in vaccine manufacturing. I mean, it went up, but not to the same percent that it should have, because we basically ran out of glass vials. It became very difficult to source the glass vials that contain the vaccine. Now, why is that the case? You think glass is easy. That's true, but not glass that can withstand negative 80-degree temperatures, right? It's actually a very specialized product. Also, of course, when this pandemic started, we were making about 4 billion vaccines a year. And the need, apparently, what the WHO said at the time was we're going to need 12 billion just of COVID. So these supplies we're not ready, right? We're just simply not ready. Likewise, then when we get into manufacturing of, say, mRNA technologies, vaccines, there was essentially 3 plants in the world that make some of the lipids that are key to the vaccine. So the idea was we need those products to go to the vaccines, to the manufacturers we know can produce a quality product. And if they get diverted, they're in limited supply, this is actually going to result in less vaccines, not more. Okay, that's kind of the argument. The third is that it would disincentivize pharmaceutical innovation. Here again, it's more like, hey, this pandemic is probably going to become endemic. And what we need is increased research and development and sustained research and development. And if we're going to take away the incentive of a profit, then we're going to, what the result is going to be less research and less innovation. And we're going to be less able not only to respond to the COVID-19 pandemic or endemic, but also to future pandemics, because companies will not rush in if they know that a waiver is going to come. Fourth is, and I think this is an important one, and this is really what even some of the developing countries had issues with early on, those that were a little lukewarm, was the proposal lacks a lot of clarity on important topics. I'll just mention here trade secrets. I mean, trade secrets are valuable and are definitely necessary for biotech. But a trade secret is only valuable as long as it's secret. And if in fact the proposal includes trade secret for a waiver, then what will you have? Governments requiring companies to turn over trade secrets? Well, they can't get that secret back, right? It's going to be very difficult, at least with a patent. Actually, the formula is well known. In order to get the patent, you have to disclose the formula. I mean, what I like to say though is, you know, if you have, and I think I'm a pretty good cook actually, but if I take a recipe from a Michelin star chef and I make that recipe and he or she makes the same recipe, are we going to have the same product in the end? Of course not. There's the know-how, right? There's the trade secrets that that chef knows that I don't, right? They're going to make a better product. So those are important. I mean, the one thing is those are important. The second thing is just because you get the formula doesn't mean you can make the product. And finally, I guess one of the bigger arguments was, you know what? There are so many manufacturers now that and so many different vaccines on the market at a very reasonable price. Most of them are priced basically of the cost of about a fast food meal, that even if we had more entering the market, it would not result in lower prices. And eventually what became the argument was, well, we have enough vaccines, supply is actually meeting demand, so we don't need this. I will say I was wrong. In the beginning, I wrote an opinion piece with my colleague Simon Lester, basically saying, well, IP might actually result in a race to get the first vaccine, and they would have market share, and there'd be a lot of wasted effort, and they would lead to vaccine diplomacy, etc., competition between China and the US. Actually, I was wrong, because now there's been 36 different vaccines that are approved by at least one regulatory authority, one country. With this competition, it doesn't really make sense for a company not to license to a qualified supplier, because if the company doesn't, another one will, right? And so actually the company is just going to be shut out of that market. This is not the case with a normal patent and monopoly. If I'm the only supplier, I can charge monopoly rates and I can, license or not license. But with 36 different vaccines on the market, and really about 6 or 7 gold standard ones, I would say, or popular ones, it doesn't make sense for a company to turn down a license, because they will just lose market share. Okay, so the negotiations weren't really going anywhere until I mentioned the US reversed their position. And I would say almost in that the WTO Director General Ngozi Okonjo-Iweala, she really led the charge. I would say not so much because she can, I think someone's drawing on the slide now, but I'm not. But not so much because she really believed that this was a great effort. I think she needed a win. The WTO negotiations, were not going anywhere in any subject, really. The Doha round had died. Fishery subsidies were still being negotiated, e-commerce, services still, and she wanted a success. And she needed a success before the ministerial conference, which was delayed due to the pandemic in 2021. Until 2022. And so she really set out to ensure that there was a result. My own personal view is she didn't really care what that result was, but she needed a win. Okay. Now, some areas were still unclear at the time. So what's the scope going to be? What's the extent? What's the durations? And at this time as well, the European Union had said, well, we will support negotiations, but we prefer to make better use of flexibilities in the trips. We don't want to take away the IP rights. They say IP is the way that we're going to get out of this pandemic. They said we need to make the flexibilities easier to use. What I like to say, they wanted to make the flexibilities more flexible. Okay, so what the Director General did was then facilitate a small group of countries, for the US, the EU, South Africa, and India, to get together and to try to reach an agreement. Now, other countries were not happy about this. I can tell you Switzerland in particular, the UK, thought, hey, this is supposed to be everyone negotiating. You can't just take 4 countries and they can decide everything. So they end up coming to an agreement, but I'm going to try to clear all drawings. There we go. They end up coming to an agreement, but I'll get that. Okay, I'll get that. Now, what we have to understand as well is that the situation is very different right now than it is in October 2020. When that original proposal was put forward, we have to remember there actually were no known vaccines or good treatments. And at that time as well, a few developed countries had pre-purchased large amounts of vaccines. So there was a serious concern that many countries, not only in the developing world, but especially in the developing world, would not receive vaccines because they were all pre-purchased. Now, fast forward 2.5 years to July 2022, it's a very different situation. You know, well, sure, we have 545 million people who have been infected and 6.3 million deaths, but now we have serious availability of vaccines. And the vaccines, I say, have worked. The vaccines have not worked to prevent the disease so well, or the virus so well. But I think it's fair to say the severity has been reduced, and most of the world have transitioned to a living with COVID type arrangements. Obviously, Hong Kong is one of the few that have not opened up. As I mentioned, 36 vaccines approved, 10 of them on the WHO's emergency list, nearly 60% of the world vaccinated. 16 billion doses will be supplied in 2022. Now, I wasn't the only one wrong at the beginning of the pandemic. The WHO was wrong many, many times, and it won by saying we're going to need 12 billion doses. Well, actually, we needed more, right? Because kids started to receive doses. People needed boosters. 2 doses was not enough. So, the situation evolved. And right now, there's few, if any, credible reports of shortages. I don't know how the situation is in Bangladesh. You can tell me if you want a vaccine, can you get one? In pretty much most every part of the world that I'm aware of, the answer to that question is yes. Far from shortages, many developing countries are now dealing with the problem of having to dispose of unused, expired doses. They're delaying deliveries because of vaccine hesitancy in some cases, that populations are not getting vaccinated. There have been some new facilities that have come online that are actually struggling to attract orders because the orders are filled. There's no need. So that reality, I think, changes things as well. We can't be stuck in a mindset. So even if I think you carry one position in October 2020, inevitably you have to change by 2022 in some ways. I'm not saying you have to say no. I was a proponent for the waiver. I'm now not. No. But we have to take into account the reality. Now, those 4 countries I mentioned produced what was called an outcome document, which was leaked in March But rather curiously, none of the four members sought to introduce it to the TRIPS Council meeting. Now, in order for a proposal to be negotiated at the WTO, a member has to introduce it and the proposal has to be circulated. Now, rather curiously, none of the four members who apparently agreed on this document sought to introduce it. Quite frankly, none of the participants, I think, really stood behind it. I think the EU and the US are happy just to do nothing. And South Africa and India didn't really show much interest either. I mean, I do have my views on India's changing position on the waiver. I think by 2022, I don't think they really even wanted a waiver. Certainly their industry never wanted it because all of their generics that won a license have one. So I think India was put in a very difficult position there. So in an unprecedented move, the Director General herself actually introduced this at the TRIPS Council, has circulated it in May. To my knowledge, this has not happened before. It's a member-driven organization and a member has to introduce. Well, that didn't happen. So again, it kind of shows you who really was the driver by 2022 of these proposals. I will say this is not a waiver. It's more akin to what the EU proposed, which was easing procedural requirements on compulsory licenses to allow for greater use of them if needed. Now, there was a lot of bracketed text, which means certain things had not been agreed, and a decent amount of opposition. So when this was introduced, a number of developing countries said, well, wait a minute, the scope is now only on vaccines, not on diagnostics and treatments. They said, it's not actually really a waiver. We're a little concerned. China was essentially shut out of supply. There was some bracketed text which said that only members who did not export more than 10% of vaccines on the market could make use of this. Well, only developing country members. Well, China is the only developing country member that exported more than 10%. So it was eliminating China from making use of this. So obviously China objected. Switzerland and the UK objected over the whole process. And activists and NGOs really came out quite against this. I actually was in Geneva in Switzerland when this meeting took place. And I talked to numerous negotiators from both developing and developed countries. No one was really happy, but a lot said, I don't even know why we're doing this. There's now a surplus. So there was a lot of skepticism. I won't go over, everything that's in that agreement. I will say, again, it just focuses on patents. It is in force for 5 years. It can be extended, but there is a hard 5-year deadline. And as I said, it waives or makes easier certain provisions in Article 31 and 31 bis to allow easier access to export and to import vaccines. I mean, there are some big wins here, allowing a country to export every vaccine it produces under a compulsory license without a big procedural hurdle. That will certainly make things easier than were the case before. All developing countries are eligible to use the waiver, but I do have an asterisk there because of some very curious language which was used, which I'll get to soon. There are some notification requirements, but they're eased again from the existing standards. And there are numerous clarifications, which I think, like the Doha Declaration on TRIPS and Public Health in 2001, may not change anything, but at least let the world know that certain things are the case. So for instance, Article 39.3 is about test data. This is saying test data protection is not a barrier here. There is no room for interpretation. That's in the decision. I think in some ways, this decision can be a huge triumph. We can view this as a huge triumph. And the reason is cooperation, and not only of the ministerial conference, but here we have cooperation, right? We have a decision which clarifies existing rules, also, of course, broadens the scope of Article 31 and 31 bis. It may have some effect. It is not going to change the world. It is not going to change everything. But at a time period where we have a struggle for the WTO members to agree on anything, they did show that they can get together and agree on something. Okay, I think that, you know, making the flexibilities more flexible is a good thing. Okay, again, I told you I was not really for the waiver, but I think easing restrictions and making flexibilities more flexible has to be a good thing. Okay, and in fact, remember, one of the arguments against the TRIPS, we can go back, was countries said the flexibilities won't work and they're too difficult to implement. This actually responds to that. And so in that way, it's a good thing. Now, I kind of finally get to what I really wanted to talk about, which are remaining issues and lessons. And I think I probably have 5 or so minutes to do this. What do we prove from these negotiations? I think this is my takeaways. What do we prove? The first thing we have to look at, and we may not like it, but we have to accept it, is that WTO cannot respond quickly to crisis. The WTO negotiating rounds, the Doha, dragged on and failed. Consensus decision-making makes it very difficult to agree on anything. Remember, if one country says no, then you have no deal. So getting an agreement it is almost next to impossible. So this is well known. You know, delay was inevitable. India and South Africa would have known this. It would have been foolish to expect that they put a proposal in October 2020 and it immediately gets agreed to. So think about why they did that proposal. I don't know. So the lessons, you know, in some ways here are the WTO cannot move quickly. But of course, the situation on the ground can change quickly, from not having any vaccines to worrying about vaccine availability in March to May 2021 to having vaccines supply outstrip demand at this point, all while the WTO is talking about a waiver, right? Talking about a proposal in October 2020 where the situation is changing. So I think what another lesson we have to learn here is there is no consensus for the belief that IPRs are a bad thing and we need a waiver in times of crisis. Why do I say these things? I say them because in dealing with the inevitable future crisis, we're going to have to find a different way to deal with things. We cannot rely on the WTO to solve the problems. Okay, they just can't move. They're not made for that. Hopefully, long term, this can lead to number 2, though. And in fact, I just received quite a large grant to look at issues like this second point, well, the first point as well, which is, should we revitalize efforts to restructure pharma R&D and distribution efforts? So I've said I wasn't really for the waiver. This doesn't mean that I think everything is great how we do it and I'm so pro pharmaceutical company and I want to just keep everything the same. No, we have to say, you know what? Trade can only do so much. We need, we need WHO to act in a different way. Perhaps a WHO treaty on pandemics, which is being discussed. We need early detection of pandemics. We need procedures in place to deal with it. We also, there's abundant scholarship in the economic and public health disciplines, which for some time have questioned whether in fact the current system provides the proper incentives for research and development to the benefit of consumers as well for vaccines, actually for pharmaceuticals in general, but particularly for vaccines. Numerous alternatives have been proposed. It's time we look at some of those, okay? Whether it be open licensing, prize funds, etc. Third, flexibilities can and should play an important role in the WTO. The WTO sets minimum standards, but we have to remember there are flexibilities which allow for pulling back those rights temporarily. And I think the ministerial decision shows it's possible to change things. What it does show is the WTO as members are not opposed to change. It takes them a while to get there, and it may be kind of watered down, but they can be flexible. And I think we really need to look at, again, how can we be flexible? Do we need to go even further in our flexibilities? Are there any holdups in the issuing of compulsory licenses? And let's deal with them. So this decision builds upon that framework and allows for the easier access. As I said, I think that's great. In many ways, I won't go into the details, but I just say it does provide for easier access. I should also mention, it does not resolve every issue. Okay. Now, again, the ministerial decision is imperfect. It's not going to resolve every pandemic issue. For one, it only deals with vaccines. Now, lots of people say we should deal with diagnostics and treatments as well. The decision says we'll revisit that issue in 6 months. Do I think anything will happen? No. But is that a major issue? Perhaps. Second, and here's something I really don't understand. As I mentioned before, the eligibility in the draft was for developing countries that export less than 10%, meaning no China. Now, China objected, and I tell you, in a spirit of really good cooperation, the US and China reached a deal. China said, as they always do at the WTO, we are a developing country and we want to be treated as one. However, voluntarily, we will agree not to make use of this, but you can't cut us out. Well, the US said that's not good enough. We don't believe you. And they reached a great compromise, and it's in footnote 1. And what it says is that countries can make a binding declaration that they will not use the system. And they put a specific date in there, a specific meeting. They say, including statements made at this meeting. There's no mention of China in the footnote, but guess who made a statement at that meeting that said they weren't going to use it? China. So China is treated like everyone else, but voluntarily says they're not going to make use of it. However, my biggest problem with this agreement is we also say in that footnote, we encourage all developing countries with manufacturing capabilities not to make use of it. Excuse my language here, but why the hell do we have this agreement then if we're going to exclude countries that can actually manufacture? Think about that. If the reason for this agreement is to increase access to vaccines, then why have the members said, but anybody who has existing capabilities cannot make use of this, or we encourage you not to make use of it? What's the point? Those are the exact manufacturers and countries we should want to make use of it if in fact access is the major issue. So I'm sorry, I have to say here, I think somewhere down the line, and perhaps when the Director General became involved, this switched from access to vaccines to actually improving industrial capabilities. So it became, we need to get more manufacturers in countries that don't manufacture. Now that's a very different to, we have a huge pandemic crisis, we have a shortage of vaccines and we need to get vaccines now. Because even as India says, it's going to take 2 to 3 years for countries to build capacity and to build a new factory and get online. Sorry, that's not in line with everything proponents of the waiver said, which are they can get online quickly and we'll have vaccines. Well, now wait, no, it's 2 to 3 years. This is weird. And even the Director General at an NGO briefing session during the ministerial conference basically said the idea here is promoting vaccine manufacturing capabilities in Africa. This is a direct quote. Likewise, the EU Director General Sabine Wieland, right after this ministerial decision, said, basically told the NGOs to be quiet and said, there's a reason that the African countries wanted and fully supported
this agreement. It's because, one, increasing capabilities, but second, I think she hits on a good point. It also gives them better leverage. So with pharmaceutical companies, the idea, and I think this is actually quite big. This is where this decision could have an effect. Not by using it, but it's there. And the branded vaccine manufacturers know it's there. Maybe they will license more freely. Maybe they will reduce prices because there's always a threat of a compulsory license. And I think the earlier change, which resulted in Article 31 bis in 2003, changed to an amendment in 2017, that was the effect. There are some other issues. Look, I think I would have liked to seen an explicit acknowledgement of least developed countries and technology transfer in the decision. There's nothing on that. There are other ways which could have been adopted as well, which weren't discussed. But whatever. I think the last thing to say here is the WTO needs to keep working though. I said the WTO can't solve things, but the WTO needs to realize its comparative advantage, and it needs to work along with others to minimize barriers to trade in vaccines, okay, and other related products. So whether that be joint studies, statistics on barriers, trying to reduce regulatory bottlenecks, these are issues which I think the WTO really could go a long way in trying to again, reduce severity of pandemics and be better prepared for the next. I won't go over, I mean, I found very curious the Indian's Commerce Minister's statement after, after pushing apparently a waiver and saying a waiver would change everything, right after the decision says, well, now it's too late, like vaccines, there's no demand anymore, everyone has vaccines. Well, why were you still pushing for a vaccine waiver then if now you're telling me that the issue doesn't even matter? We have vaccines that are expiring, you know. I don't get it. I won't talk more because of time on that. So I'll just come to the conclusion, which is, I think it remains to be seen what, if any, effect this ministerial decision will actually have on vaccines. As I said a minute ago, I think if it encourages more voluntary license and diversification of manufacturing, in the long run, this is a good thing. I think the WTO should be commended, the members, for proving that it can be flexible. If it takes a long time, but can be flexible by flexibly applying the flexibilities. I think the focus really, and I've always said this throughout from the beginning, I think the focus was wrong on a waiver. I think the focus should be, hey, is there capacity? Is there manufacturing capacity out there? If there is, we need to make sure it's filled. We need to make sure they get a license. And obviously on continuing research and development. And I think it should be clear that changes to IP alone are going to be insufficient for ensuring effective global vaccination. They might play a role, but it's not going to do everything. Technical and logistic problems, complexities associated with vaccine deployment, growing hesitancy in terms of taking vaccines. These are all real barriers that actually have very little to do with IP. And I think the key lies in understanding these barriers to ensure equitable distribution of vaccines. And also we do need to look at, again, how the WTO can play its role. So the decision here, the ministerial decision, I think combined with other efforts to increase and improve production capabilities, licensing, distribution, reduction of blockages and bottlenecks, could go some way in ensuring sustainable access and hopefully putting us in a better position when we come to the next pandemic. So I will end there and hand it back to the chair. So thank you for listening, and I welcome all questions and comments.
Thank you, Professor Mercurio, for your excellent presentation. We have several questions. The first question that I would like to put to you is on the flexibilities that you were referring to. The question asks that how is this waiver fundamentally different from Article 31 or 31B's flexibilities? I think you have sort of discussed this, but not maybe at length. So maybe you could add to what you have already said. Thank you.
Sure. So one of the, again, just to go back, one of the real issues in the early 2000s was that the Article 31 of TRIPS required that if you issue a compulsory license, the predominant supply has to be for your domestic market. Now, what that meant is countries that don't produce pharmaceuticals or don't produce them in large numbers really couldn't make use of the compulsory license provision because they would have had to import them, and that couldn't have happened. So Article 31B is the members got together and they kind of fixed this. So they allowed for the export of export of pharmaceuticals under a compulsory license. Now, procedurally, it's a little tricky and challenging. So what you need is the country that wants to import the drug to issue a compulsory license, they need to find a supplier in another country, then they need to get that country to issue a compulsory license, and etc. And there's notification requirements to WTO before it all happens, etc., etc. What this does is it extends it, really. What this means is it essentially tries to cut out some red tape. What they're saying is, well, first of all, the notification procedures to the WTO can actually happen kind of after, not before. Second, in order to avoid having to negotiate with the rights holder first, you have to have what's called an emergency or national emergency, or it has to be a special circumstance. So what this waiver also does, or what this decision also does, is to say, this is a special circumstance. You don't need to prove it, okay? You can go straight to negotiating with the generic. You don't have to negotiate with the rights holder first. And third, and I think most importantly, it cuts out some of that red tape as to the exporting country issuing the compulsory license as well. So it really, per se, allows for a company in a different country to export all of their supply to a third country under this compulsory license. So really, I mean, for all intents and purposes, this simply is an extension of what we had agreed to in 31bis, and it tries to address a lot of the criticisms which have been in place of 31bis since the beginning. So that's why I say it's taking a more flexible approach to this existing flexibility.
Thank you for that answer. The next question is on this waiver coming too late, as you have rightly said that it was perhaps too late to come. So in a future pandemic or in a future public health emergency, which extends beyond one country and is a global crisis, what do you think this waiver tells that what should be done, maybe on a permanent basis, or maybe at least work much more promptly than what has happened to COVID-19?
Yeah, I mean, this is the, $2 billion question. I think, we need to take lessons, right? And we need to take lessons. And what, initially happened, I think the WHO was caught flat-footed. I think they really were very political at the beginning and they didn't do what they should have done. Countries really retreated into very much protectionism, I think, even amongst EU countries, which is very surprising. I don't think we've seen that before at the EU level. And I think that what we've seen is it took some time to work out, but in fact, equilibrium kind of returns. And if we can make sure that happens at an earlier stage, this is a good thing. Setting up the COVAX system of the licensing, setting up a system which mimics really what we have for HIV and malaria and tuberculosis, which is essentially a central licensing system where a company will say, yes, I want to be a member of this. And it allows those, that central system using basically pro forma contracts to license out. I think this is, it took some time to set that up now for COVID. It took some time for companies to sign up to that as well. I think that in a future pandemic can be done at an earlier stage. I think what we saw, which is a good thing, is companies actually did work together. We had many joint arrangements, licensing. What I will say, which was somewhat criticized, but it was absolutely instrumental, was mainly the US pre-purchase agreements, which on the one hand, people say, well, that meant the US locked up supply. Sure, but those drugs would have never gone to clinical trial stage at the stage they did without that US investment. So the US would invest, $1 billion, 500 million in a company. It allowed that company to progress their research. And in fact, many of the efforts turned out to, to not come up with any solution. So we shouldn't have to rely on the US investing to ensure that the vaccines get developed at a quick stage. I would like maybe some, obviously the US is going to put in, would be financially quite heavy, but maybe some sort of fund to allow that to happen and make sure that we can get this R&D done at an early stage. I really think it's a tremendous achievement that, within a year of essentially discovering a novel coronavirus, we had vaccines in testing stage and numerous different ways to attack the vaccine as well. It's really as amazing to me from a scientific point of view. I don't have that much hope that, at least in the short and medium term, that we are going to revise. I think my point number 2 was that we should look at different alternative ways of R&D and distribution. That's long term. I don't think that's going to happen anytime. There are too many vested interests, and you need to convince all of those vested interests that it is in their interest to try to change things. I do think we should start looking at them in a more open-minded way and think, hey, there may be a different way to do it, and the pie will get bigger, and so you're actually not going to get hurt. But you asked me what I think will happen next time, or in the short and medium term. I don't think that'll happen, but in the long term, I think we might be better off.
Thank you for that answer. There are 2 questions that I think are related somehow, so I would ask them together. One is on the explicit lack of explicit reference to LDCs in the waiver, which I think you have mentioned in your presentation. That what could the TRIPS do, or should there be more flexibilities for LDCs to develop their technological capacity to deal with pandemics like this? And secondly, how to ensure greater equitable distribution of vaccines and other treatments in emergencies like this? So your thoughts on that, please.
Yeah. So the first question again, can you just repeat that one?
Sure. It is on that how can the TRIPS ensure greater?
Yeah. Okay. The LDCs, look, I think that, again, this decision has certain parts to it, which I say I don't really think change much, but clarify or reinforce certain things. I think it should have been a good nod and would have been appropriate to at least clarify or reinforce, encourage members to stand by Article 66 of TRIPS and transfer technology. It wouldn't have perhaps made a difference on the ground, but it would have been there. In particular, because it seems to me that by the time this was decided, and certainly from the Director General's point of view, this has become a longer term industrial policy decision rather than a shorter term access to vaccines decision. In that case, the diversification probably we want in LDCs as well. Actually, I have to tell you, Professor Rizwan, that in my big project, I will have 4 case studies about potentially countries of potential vaccine local productions, and Bangladesh is one. So, so I hope to visit and look into this. So what I think, and it leads to the second one, is if that's the case, what we probably need to do is hubs, is little vaccine hubs, right? We can't, and we have to be smart about it. You know, every country can't start a manufacturing plant. There's no economy of scale there. There's too many things would go wrong. The availability of parts, things, it would be a disaster. But perhaps we can focus on regional efforts. And this isn't, you know, a lot would need to be done, because what we might need to do is to have actually most favored nation waivers then. We need to make sure in a region that that vaccine, regardless of where it's produced in the region, can go, you know, duty free, can be, that will get regulatory approval, etc. So a lot of these are not IP issues, right? Some are trade issues, some are regulatory health issues, obviously infrastructure issues as well. We need to make sure that, you know, that if it needs to be kept cool, that in fact there are destination points in all of the regional countries that can store those drugs, that have stable electricity supply, etc. So there's a lot of on the ground work that, you know, if we set up these factories, can lead to better outcomes, earlier outcomes. Right. I think the problem now to me is not, again, lack of availability. It was just the timing of that availability. And certainly there were delays in developing and least developed countries, because most were relying on donations. The problem here, and I understand it, is that we can't just have build manufacturing plants, sit around and wait for the next vaccine. I mean, this is a big waste, right? So another thing we have to do is, well, what are they going to be producing in the meantime? What are they going to be producing now? And we need to ensure that we can quickly, what they call retrofit them to whatever we need next. That will take money, that will take expertise, but starting now to try to address those issues seems to me to be a good idea. To me, by 2021, you know, and I know I'm in the minority, but I was already looking, my view were shaped not by COVID. My view has been shaped by how can we better prepare for the next, right?
Thank you so much for that answer, and glad to know that Bangladesh would be a part of
Yeah.
your study, or potentially a part of your study. We're already out of time, but I would take this opportunity to ask one last question. That how do you think this potential ISDS claims may play out with regard to any country using the waiver? Your thoughts on that?
Yeah, I don't think they will. I don't think they will. And 2 reasons for that. One, what should I say? One, I guess I would say it'd be very bad publicity. It'd be very bad publicity, and actually, I think a difficult case to win. I mean, as you know, and I'm sure as your students know, you know, each bilateral investment treaty is different. So, you know, there are different levels of safeguards. The commitments are drafted in different ways. So I won't say, let's assume there was a full-on waiver as per the proposal in October 2020 or May 2021. That would have made a case easier to win, but still very difficult. I think the tribunals, at least involved in the cigarette tobacco cases, trademark cases, have shown a large amount of deference to host governments who can come up with a plausible public interest reason for adopting something. I think that it's for taking a certain measure, for it not being arbitrary, etc. I think it's also very clear that even a violation of another treaty does not mean a violation of fair and equitable treatment per se. Well, here it's something in line with another treaty. Again, that doesn't trump, but I think that would be taken into account. But the second reason is, of course, now this is really it's even a watered down proposal, right? It is just basically changes to procedural rules of an existing flexibility. You know, most treaties, particularly the investment ones that are wrapped up in a larger FTA, will kind of reference something about the TRIPS agreement at some stage. So I still think it'd be very, very, very difficult for a country taking a measure in line with TRIPS to be found to be violating a bilateral investment treaty. Now, and in the paper I published with Pratush Upreti, who's at Queen's University Belfast now, what are more pressing, or our concern was if it was really with trade secrets, that could have been the issue that really could have led to a violation, because at that point you really are taking and you're not giving back. And so if there were domestic legislation forcing, and I don't know, doing with some sort of sanction if the company didn't transfer that trade secret, then that may become an easier case to win. But that's just not what is in the ministerial decision now, so we don't have to worry about that.
Thank you for that answer and for your excellent talk once again. Thank you to the audience for their participation. Have a good day.